And welcome to this morning's webinar on redundancy, trip hazards, and importantly, how to avoid them. My name is Sam Greenhalgh. I'm a partner in the employment team at Birketts, and I am joined by my lovely colleagues who I will introduce in a moment. We have around 500 people live watching this recording right now, representing a wide range of different businesses and organisations, all of which, of course, are employers and will be grappling with redundancy from time to time, unfortunately. Redundancy is a huge topic to cover. And so what we've done is picked three main areas that often come up to be considered by an employment tribunal to see whether the employer has acted fairly, reasonably, and or possibly in a discriminatory fashion, which we will take a deep dive into and try and demystify for you. In preparing for this seminar today, I looked at the Office of National Statistics employment law report, and in the last quarter of last year, 2023, October to December, there had been a 25% increase in the people who were interviewed stating that they had been made redundant in that previous quarter. And that follows a trend throughout 2023, where unfortunately employers are looking at redundancy as part of their people strategy. Going into 2024, it's likely that that trend will unfortunately continue. Of course, we've got a lot of change happening in 2024 as well, with an election on the horizon and a potential change in government. So please do hold on to your hats and make sure that we will hopefully endeavour to look after you as much as we can during the course of the year. I'd like to introduce my colleagues. First of all, Sonia O'Reilly is a partner in our employment team, and she advises lots and lots of clients in the education and charities sector. Sonia is also a trained mediator, and she is able to help employers navigate issues where employees have perhaps fallen out, where there's a falling out between the line manager or between colleagues. Before it developed into something much bigger and much more difficult to manage. So if you have that requirement within your organisation, reach out to Sonia, who would be able to help. We also have Olivia Toulson, and Olivia is a legal director specialising in advising clients in the financial sectors, technology and life sciences. And we have Lucy Churchill, who is a senior associate in the team, and Lucy has a large amount of experience in advising on complex employment tribunal litigation and employee relations issues, and she is described in the legal directories as a rising star, very efficient and very, very personable. So that is our panel for today. Sonia is going to kick off with an employment law update. And then Olivia and Lucy will take us through the main part of the day. And then at the end, we are going to have a question and answer discussion. So please do feel free to raise any questions that you may have in the Q&A icon that is listed on the top ribbon of your Teams screen, not the chat function. Please raise it in the Q&A function, and we will endeavour to answer as many of those as we can. We already have a long list of questions that many people have raised in the sign up to this event, and so we will endeavour to answer those during the course of the presentation, and as many as we can in the Q&A section at the end. One final notice from me is that next week we have our mock employment tribunal taking place in Newmarket. That's on Thursday next week. We have an employment tribunal judge and two barristers, and various members of the Birketts employment team are going to be witnesses. And the claim is involving a constructive dismissal and sexual harassment case. and you will be able to see what happens inside an employment tribunal room, albeit in a fictitious stage scenario, and we will break away with lots of interactive discussions, and you'll have the opportunity to ask questions yourself as well. So if you haven't signed up already, I know many of you have, we have about 130 people already signed up, then there are a few tickets remaining. Please scan the QR code or follow the link on the slide there. The webinar is being recorded, so you will be able to share that with your friends and colleagues after the session today, and also refer back to it for future use. So please don't worry about taking copious amounts of notes, and I hope you've got a cup of tea or a cup of coffee with you. And I'm now going to hand over to Sonia, who's going to take us through an employment law update. Thank you, Sonia.
Good morning, everybody, and welcome. And I really look forward to just sharing with you some thoughts now and updates on where we are at the moment in some of the updated case law and particularly some legislation updates over the next few minutes. So, first of all, a little update on the national minimum wage. Now, this is due to increase from the 1st of April, as it does each year. And really, I think one of the things just to be aware of is that the national living wage is going to be extended from workers who are aged 23 and over to those aged 21 and 22. So where it used to be the national living wage simply for 23-year-olds and older, it's actually going to be extended now. So those people who have been paid at a lower rate previously will be increased to that national living wage. So make sure that that is on your radar. There's also a rise in the other figures for the national minimum wages. And actually, these represent one of the largest rises that there has been ever with the national minimum wage. The intention there is to reflect the fact that inflation, of course, has been running high, as has the cost of living. And so the government has made those higher level increases in order to address that particular issue. Another little thing just to be aware of is that the Low Pay Commission is currently carrying out a review of the national minimum wage generally. And they are considering, and it's only a consideration at the moment, but they are considering whether to apply a single adult rate from the age of 18 rather than having these different rates dependent on age up to the age of 21, 22. So that's something just to keep an eye on, but at the moment, just being considered, no changes actually planned. But you've got those rates there then on the screen. Hopefully they're useful for you. And in terms of rates and things changing, and this has literally just come out on the 26th of February, so just earlier this week, the government has made its announcement that it does each year about rate increases for things like tribunal claims and maximum awards. So you don't have a slide on this because this is literally hot off the press, but the new rates and limits that will come into place from the 6th of April this year. Just a couple of headlines on those for you. The rate for unfair dismissal, the maximum unfair dismissal award, remember it's 1 year's gross pay, but capped at a maximum amount. That limit is moving up from £105,707 to a slightly more easy to remember, but bigger number, £115,115. So 115,115. And a week's pay is rising from £643 up to £700 as the statutory week's pay figure. There's lots of other rises, but those are just the headlines that I wanted to just let you know about. Okay, then moving on to some family-friendly information and details. And actually, these are pieces of legislation that you might well have heard us talking about really for the last few years. So this is now confirmed to be coming in from the 6th of April. So this is carers leave. As I say, it's one of those parts of family-friendly changes and legislation that's been discussed for quite some time. And it's a new right for carers from day one, where they have a dependent that they're caring for who has a long-term care need. Now, a dependent is classed as a spouse, civil partner, child, or the parent of the employee, or indeed someone who's in the same household as them who relies on that employee for care. And that individual must have either an illness or an injury, whether that's physical or mental, that requires or is likely to require care for more than 3 months. or someone who's got a disability for the purposes of the Equality Act, that would class as somebody who has this care need, or indeed somebody who requires care for a reason connected with their old age. So for those people who are looking after elderly parents, this would be a type of leave that they might be able to avail themselves of. It's a maximum of 1 week's unpaid leave that can be taken in a rolling 12-month period, either in a single or half day or blocks of up to 1 week. And it's for the purpose of either carrying out and providing care or arranging care. There are notice requirements, as you can see set out there on the slide. And it is possible, but in limited circumstances, for the employer to postpone somebody's request to take that leave. They can't refuse to allow someone to take leave, but you could say in limited circumstances, such as where you might say it's going to cause undue disruption to the business, for somebody to take a block of leave at a particular point, perhaps at your busiest time of year, but it would need to be postponed and done carefully. And there's some rules around that you'd need to look at. So carers leave coming in from the 6th of April. Next, again, still sticking with the family-friendly theme, the other change that's confirmed to take effect from the 6th of April is the change to flexible working. Now, the Employment Relations Flexible Working Act 2023 is going to come into force, and it amends basically those existing flexible working provisions that we've been working under for quite some time that were set out in the Employment Rights Act of 1996. So, what does it do and what do you need to be thinking about? Again, this has been pretty well publicised. It's been something that's been in the press quite a lot as well. So this revokes the requirement for an employee to have a minimum of 26 weeks service before they're able to make a flexible working request. That means it's a day one right. As you'll see there set out, that the other changes that are going to be brought about by this new amended legislation is that people will be able to raise 2 flexible working requests in a year rather than 1, and that there's reduced time periods for you as the employer to respond to that flexible working request. You used to have 3 months unless agreement was reached between the parties to extend that time. Now it's 2 months. Still possible to extend by mutual agreement, but the intention is to try to ensure that employers are dealing with these requests as quickly and efficiently as possible. Something else that's changed here is that the employee will no longer be required to need to explain the effect of the change that they're requesting. In the past, or in the current system up until April, the employee has to set out what they think the impact of any of their proposed changes might be. So if they're wanting to reduce their working days, for example, they would need to currently explain the impact that that change would have and how they feel that that would be managed. That's not going to be a requirement for employees going forwards. It's more about what the employer, so pushing the onus really onto the employer to make those decisions and carry out that sort of analysis of what the impact might be. It is still going to be possible for the employer to refuse or reject somebody's flexible working request. Those 8 reasons that are set out in the Employment Rights Act are going to remain unchanged. So employers can still look to those business reasons. But remember, even with those business reasons, and whilst you can reject a request, there is always that sort of wider issue when looking at flexible working as to whether somebody might be able to claim indirect discrimination on any ground if you're refusing a request. So those challenges still very much remain. There has been a new ACAS Code of Practice that was published on the 11th of January in relation to this particular new flexible working arrangements. It's awaiting parliamentary approval at the moment, but remember those ACAS guides can be so useful, really practically set out and very helpful, but they are non-statutory and they are there to assist and try to help you understand how to deal with those kind of flexible working requests as an employer. Okay. Again, sticking on the same theme of flexible working, I've got a case here to update you on. Now, this is a first instance case. That means it's just been heard at the Employment Tribunal. It's not a case that's been appealed to a higher level court. So it's simply indicative of how a tribunal might consider some of these issues around flexible working. It is not a binding precedent, but nonetheless, we thought it would be really useful to flag it to you because I think it's something that is coming up quite a lot at the moment. So, what's it all about? Well, this particular person, Wilson, had been a senior manager at the Financial Conduct Authority for some years. She was, as it says there, a senior manager, and she'd been working full-time from home since the beginning of the pandemic. So you can probably sense what's going to happen with this case already. But this is a case where the employer, the FCA, decided that actually they wanted to shift back to being in the office a bit more. So they required then all their employees to return back to the office for 50% of their time, so operating a hybrid working pattern. Now, this particular employee, Wilson, decided that that was really going to be quite difficult for her in her view, and she made a formal flexible working request to work fully remote, so to continue working the pattern that she had done since the beginning of the pandemic. The FCA refused her request. What they said was that they really wanted her back in 50% of the time because of her managerial responsibilities. They felt that her continuing to be entirely remote was going to have some detrimental impacts on quality of output, but particularly they were focusing on her leadership role, the need for her to be there to collaborate and to mentor, and particularly also she carried out quite a bit of training, and the functions of training were felt to be something that were much better captured by being face-to-face rather than remote. In addition, she was involved in lots of management meetings because of her role, and that was also something which the FCA suggested would be helpful for her to be part of in a face-to-face capacity for at least half of her working week. Now, I think this sort of case is a really topical one. It's certainly one that myself and my colleagues are seeing quite a lot of interest in, these sorts of issues from employers where they're trying to encourage employees to return back to the workplace on a hybrid basis, or indeed in some cases fully, even though that seems to go against perhaps what employees seem to be wanting in certain sectors. But nonetheless, here the Employment Tribunal held a couple of things. So firstly, and the smaller little part of this puzzle really, is that the employer was found to have breached the time requirements, the statutory time limit that's currently 3 months, but is going to be 2 months for responding to a flexible working request. And the employee was awarded compensation there of 1 week's pay. So not an enormous amount of compensation, but that's the way that the structure of the flexible working request regime goes. Then the next thing that happened was that the tribunal then considered whether or not it was right for the FCA to have rejected the request to work flexibly in the first place. What they found there was that, yes, the employer was entitled to reject that request. And what they really looked at was the needs of the particular employer for that employee in her particular role to be present. And I think that's the key here, really, for you to be thinking about what is the role and what is the requirement, because it's not always going to be the case that an employer will succeed in saying that a flexible working request will need to be rejected if someone wants to work from home. It's really all about what is required. But interestingly, the tribunal here has been willing to find that an employer was entitled to say that people need to be within the workplace physically from time to time. Okay, then finally on family-friendly positions, the next point is to do with the couple of minor issues here on paternity leave. There's some small changes from the 6th of April that are coming into effect under the paternity leave amendment regulations. They're coming into force from the 8th of March, but they actually take effect in relation to children whose expected week of childbirth or the expected week of placement for adoption is on or after the 6th of April. So the changes that are going to be in place are that the current entitlement to 2 weeks statutory paternity leave will remain, But new fathers and partners are going to be entitled to take the leave in 2 separate blocks of 1 week, rather than having to take 2 weeks as a single block. The time frame for taking statutory paternity leave is going to change, so it can be taken at any time in the first year, rather than just in the first 8 weeks after birth or adoption, as it is at the moment. And there's going to be some changes to notice requirements as well. So what do you need to be doing then in light of these various changes to flexible working and the various different leaves that are going to be adjusted? Well, it's all about reviewing and updating your policies, making sure that your flexible working policies and your paternity leave policies are updated to take account of these changes. And you need to introduce a new policy on carers leave if you don't have one already. But critically, of course, the policies are all very well, but you then need to make sure that managers are aware of those changes and know what to do when any of their employees and their direct reports come to them asking for support and one of these periods of leave. Now, everyone's favourite topic, working time. A couple of points just to flag. Again, you might well have heard of these. These have been very highly publicised, but really worth just keeping them on your radar just as we move forwards in this update. So the first point is that as a result of Brexit, we've had this issue of the potential for all of the EU derived legislation to be scrapped and burnt, and that actually didn't happen. This bonfire of rights didn't happen at the end of 2023, as was mooted at one point. So what we've got here, though, is that there has been a post-Brexit amendment to the working time regulations that took effect from the 1st of January. And these are the changes that are set out there. So these are all in relation to that for the 4 weeks of holiday under Regulation 13 of the Working Time Regulations. So it's just that 4-week period. And they're set out there for you. So it's about the payments that are going to need to be included in the calculation of holiday pay. So that will be commission that's intrinsically linked to the performance of tasks that a worker is contractually obliged to carry out, payments for professional or personal status relating to length of service, and payments such as overtime and those sorts of things that have been regularly paid to employees and workers in the previous 52 weeks. There's also changes to the ability to carry over holiday, as you can see there on the screen, and the temporary change, the Working Time Coronavirus Amendment Regulations 2020, which allowed carry forward of up to 4 weeks of statutory leave because of the pandemic and the inability for people to take their leave during that time, will run out. So that's now been repealed, and carried over leave must be taken by the end of March. The other part that I just wanted to flag to you quickly on working time is the Harper Trust and Brazel issue. So these are amendments that the amendments that the government has brought into effect to try to address the Supreme Court's decision in Harper Trust that came out in 2022 to do with the fact that there was to be no prorating of holiday entitlement for those working only part of the year. That caused all sorts of upset, particularly within education and sectors where there was significant amount of term time only working, for example, but actually in any sector where there's anybody working only part of a year. It meant that there was a difference to the way in which holiday could be calculated, and it needed to be calculated, and then a worker would be entitled to 5.6 weeks of holiday pay, even though they might only be working for a limited period of the year. And in the Harper Trust case, she was only working for 13 weeks of the year, but entitled to the full 5.6 weeks of holiday. So to address that, the government has issued some amendments to the working time regulations, and these are set out on the screen. And it's really about some changed definitions of an irregular hours worker and a part-year worker. And for those types of workers, accrual of holiday is now basically going back to how it was before Harper Trust, which is that you still now can then look at that 12.07% calculation to work out the entitlement to holiday that somebody has for leave years that are on or after the 1st of April. Now, There's also now a change so that rolled up holiday pay is permissible, which has not been permissible for a long time, but that is now going to be something that can be adopted. So some changes there that are hopefully helpful, but unfortunately, of course, if you took the decision to adopt the Harper Trust ruling, which was the correct approach at that time, you might now need to engage in consultation to change again to go back to this position that the government has now brought in. So that's something you might need to seek some advice on if you have any particular issues there. Okay, and finally from me, before I hand over, this is something that is, again, a newsworthy item, I think, and something that has caused quite a lot of chat in the press over recent years. So you may recall on the back of the P&O ferry debacle, the government was particularly concerned about the impact of what is sometimes called hire and rehire. Fire and rehire, or dismissal and re-engagement. And so in January 2023, the government launched a consultation on a draft code of practice that's aimed at providing some real practical guidance on the purpose and really with the purpose of trying to promote good industrial relations and to try to help employers understand how they're going to carry out these sorts of processes where somebody is considering making changes to somebody's contractual entitlement. Remember that in order to change someone's contractual entitlement, you need to seek their agreement to that change. But if they will not agree and you've gone through a process of consultation, if somebody will not agree to that change, it is possible to dismiss them on their current terms and conditions and re-engage them on the new terms that you would like them to be on. So this code of practice that has actually just been published on the 19th of February, so again, very recent, has published the responses and a revised draft code following the consultation process. It's really worth you having a look at this. The ACAS guide is very usable. It is easy to read, well, as easy as is possible with what is quite a complex area. Remember, with any ACAS code of practice, it is something which is not statutory in effect, and it hasn't yet been approved by Parliament. It's expected to be approved in the summer, but it's not something that is of itself something somebody can bring a claim about. But if you fail to follow the code once it's in force, then it is admissible in evidence. So somebody can bring it as part of another claim suggesting that you have failed to follow this code, and there's a potential 25% uplift for unreasonable failure to follow the code, an uplift on compensation. So one of the things that I think is worth just flagging is that actually the whole intent behind the code is to make dismissal and re-engagement absolutely the last resort for an employer. So as you'll see, they're set out. Those are some of the key points that are set out in the code. There is a need to contact ACAS at an early stage before even raising the issue of dismissal and re-engagement with the workforce. So those are things to be aware of. But it's certainly something that you will need to familiarise yourself with before any consideration to even begin consulting or even thinking about consulting on proposals to change contracts of employment once it comes into force. However, of course, if the Labour government if we end up with a Labour government after the general election, they have already said that they would abolish fire and rehire as a concept. So we'll watch this space. Okay. That's all from me. I'm going to hand back now to Sam and then to Olivia, who's going to take you through our session on redundancy.
Thank you very much for that, Sonia. My session is going to be around looking at redundancy. So we're going to be looking at some of the key concepts. We're not going to be looking at collective redundancy today. We're just going to be focusing on the individual. So we're going to start first of all by doing a refresh of what statutory redundancy what the requirements are to meet a statutory redundancy situation. So first of all, we're going to look at some of the case law, and then we're going to move on to some of the specific aspects of how we achieve a fair redundancy. So the first situation where redundancy arises is where a business is closing. So in other words, the whole company is going. The second situation will be where a workplace is closing. So in other words, this is where an office or a site of a business is closing, but perhaps other offices, other sites might still be continuing. So both those are fairly straightforward. The third area of a potential redundancy situation is where neither the workplace or the business is closing, but there's a reduced requirement for employees. So in other words, either because workloads have dropped off, perhaps we've lost a client or a source of income, or a stream of work, or a project has come to an end, we've lost funding, something like that. Or we've just found new ways of doing existing work more efficiently. So for example, a new piece of technology. A classic example might be where in a supermarket we had lots of individuals who would work on the checkout tills. We now often have self-checkout tills, so we don't need as many people as we once did, and therefore a redundancy situation has arisen. So typically a tribunal won't examine in too much detail the business rationale for a redundancy situation. They accept it's a commercial decision, often a commercial decision that is beyond scrutiny or excessive scrutiny. So this is quite different here in the UK as you would get in some foreign countries. So for example, in France, you're actually required as a business to open up your books, your financial books, and prove that a redundancy situation has arisen and that there is a commercial need for saving costs. Having said that, that's not to say that you shouldn't provide any explanation or justification at all. That is still required, and that does still form part of the consultation process. It's just more that a tribunal is more likely to sort of accept it and won't dive too much into the business finances. The only situations where that probably doesn't occur is where there is evidence that the decision was a sham in order to target somebody or a particular set of people. So just examining the three different scenarios in a little bit more detail. So when we're looking at a business closure, we're not solely looking at permanent closures. We're also looking at temporary closures as well. So this might be, for example, where we've had to close a business due to temporarily for refurbishment purposes, or there's been a temporary drop-off in work only to later be able to resurrect it. So temporary business closures can give rise to redundancy situations as well. When you're looking at a workplace closure, the employee's place of work often then becomes an issue that we have to start thinking about, and you have to think about beyond what is simply stated in the employment contract as the place of work. You need to look at the factual circumstances. Where is the individual on a day-to-day basis? How much time are they spending working in different offices, working in different sites, that kind of thing. There's often cases where individuals actually split across two workplaces. So instead of focusing on whether there's been a reduction in the need of a particular workplace, we're looking at focusing on whether there's been a reduction in a particular type of work that's been done. So not the geographical location of the individual concerned. So this is where the bulk of the case law lies, really, and it does reflect the fact that workforces are often now geographically spread around and organised into teams, and lots of teams or teams can work in different places. So the leading case on establishing whether an employee was dismissed by reason of redundancy is a case called Safeway Stores and Borough. It's a 1997 EAT decision, and it was approved by the House of Lords in another case called Murray and Foyle Meets. And in both those cases, they approved a sort of 3-stage test that needed to be followed. So the first question is, was the employee dismissed? So has the employee actually, their employment has ended, and was the employment terminated by the employer? And what was the reason for dismissal as well? And then we look at the requirements of the section in the Employment Rights Act on what a redundancy is, and look at whether there's been a requirement of the business for employees to carry out work of a particular kind, whether that has ceased or diminished. If so, was the dismissal of the employees caused wholly or mainly by the state of affairs that has been identified in stage 2, so the reduced requirement for individuals? And only where you answer yes to all 3 of those can we establish that a redundancy dismissal has taken place. And redundancy is obviously a potentially fair reason. It's one of the 5 potentially fair reasons for terminating an individual's employment contract. So one of the first questions a tribunal will look at whether an employer has acted reasonably. And in determining reasonableness, tribunals often look to a case called Polke. So it's a very old case, but it still gets referred to numerous times in employment tribunal situations whereby the parties are looking at overall fairness, procedural fairness, and what would have happened had the procedure been followed in the way the tribunal has said it should have been. So in Polke, the employer needed to reduce overheads, and so decided that it was going to reduce the number of its van drivers, one of whom was Mr. Polke. So without any warning, without any prior consultation with either the affected representatives or elected representatives or employees, a manager advised employees that they were redundant and simply handed them redundancy letters. A tribunal, with which the EAT and Court of Appeal actually agreed, held that the individuals had not been unfairly dismissed, because they came to the view that even if the employer had consulted them, they would have still been made redundant in any event. So this is where this concept of the Polke test sort of had the procedure been followed, it would have made no difference to the outcome. However, the House of Lords disagreed, stating that in the case of redundancy, the employer isn't normally going to be held to have acted reasonably unless they warn and consult employees or the elected representatives, and that they have followed a fair basis on which to select individuals for redundancy, and they've looked at ways in which to minimise the impact of redundancy, perhaps by looking at redeployment within its own organisation. So in summary, what they decided was that a fair consultation means that a company has to warn and consult employees or their representatives about the proposed redundancy. They have to adopt a fair basis on which to select for redundancy. So that means identifying an appropriate pool from which to select potentially redundant employees, and then selecting those individuals from that pool using proper objective selective criteria. And then the final stage of establishing a fair process is considering suitable alternative employment. So there is an obligation on the employer to search for and, if available, offer suitable alternative employment within the organisation. So tribunals generally now have to consider Polke in all situations where they're looking at reasonableness. So moving on now to look in a little bit more detail at consultation. So consultation is a crucial part of achieving a fair redundancy dismissal. There'll be really hardly any cases where a tribunal concludes that a process would have been futile and the dismissal was still fair. what the House of Lords actually said in the Polkey case is that only in exceptional circumstances might it be reasonable for an employer to have concluded that consultation would have been either utterly useless or completely futile, and thereby making an otherwise unfair dismissal fair. There's actually very few reported cases where employers have successfully argued that consultation would have been utterly futile. What tribunals tend to do in practice is they're more likely to find that the dismissal was unfair, but to reduce the compensation that's awarded on the basis that consultation would have made no difference to the outcome. So they will look at they'll sort of apply a percentage chance of a particular outcome happening, and then reduce the consultation. Reduce the compensation that's awarded to the individuals. There is, however, one example, though we wouldn't really recommend that you sort of follow it. I think it was probably one of those outlier type cases, but it's a case of Ashby and JJB Sports back in 2012. It's an EAT decision, and in that case it was the EAT concluded that it was fair to dismiss a senior employee with 10 years service without any form of consultation, simply on the basis that JJB was having to act with speed and altruisticity. It's very risky in practice to do that, and it's certainly not going to be applicable in a situation where you're looking at collective consultation, when you're looking at dismissing more than 20 employees within a 90-day period. That has an entirely different set of case law around to what extent it might have been unreasonable to reduce that statutory consultation period. So following other EAT decisions, looking specifically at the right to be accompanied, this is often a question that we get in practice. To what extent do we need to let somebody be accompanied to a redundancy consultation meeting, as opposed to a meeting that might end in confirmation of their redundancy and therefore termination of employment? So what the case law says and what the legislation and guidance around this area seems to say is that because the consultation meetings are not disciplinary hearings, you are not required to give somebody the right to be accompanied. Nevertheless, it is generally good practice to allow somebody to allow an employee to be accompanied by a trade union representative or workplace colleague at such meetings. And quite often, employers have it inbuilt into their policies already. So if in doubt, it's probably not a bad thing to do. So what should be consulted on? So a quick summary here of the type of thing that we need to be consulting on to make sure that we are following a fair redundancy process. So first of all, we need to consult or certainly explore the business rationale that underlies the reasons for needing to make redundancies. So this is your explanation that you provide to the individuals as to why the redundancies need to take place, and typically this will be because there is a reduction in income from the company, we've lost clients, or just a general economic downturn has meant that the business isn't making as much money, costs have gone up, that kind of thing. What an individual probably want to know more about is why their particular team. So yes, the business might be in difficulties generally, but why have you chosen that particular team and those particular people? The second area for consultation is around the basis of selection. So this is the pool, so the pool in which you're looking to reduce headcount from. So if you've got a situation where there is only one individual who's doing a particular type of work, then you're selecting essentially from a pool of one. So we call that self-selecting. So you'll need to be able to explain the rationale for this. So why have you chosen to consult with? So why have you chosen a pool of one? And are you comfortable that there aren't other individuals who perhaps do similar work, that there isn't particular crossover, or that or that other people in a team couldn't sort of act in a sort of interchangeable way, and that does involve looking at the factual scenario as opposed to just looking at what job titles are, or what on the face of it an individual seems to be doing. The third part of that is looking at selection. So first of all, you need to have put in place objective selection criteria. And once you have applied that criteria to the individuals in the pool, you'll need to be looking at the scores that have been generated as a result. So once an individual has been scored, you should provide them with their scores so they can challenge any areas that seem to be unfair. We wouldn't necessarily advise handing over everyone else's scores to everybody else at this point, but they can be provided perhaps on an anonymous basis a bit later down the line if needed to achieve a fair consultation. You need to make sure still, even at this point, even though you've scored people and you think you've worked out who is at risk and who is potentially safe, you need to make sure still that you're telling everybody that no final decisions have been made. And you need to be saying that not only to the people that have potentially been selected, but also the people that are potentially safe. So those scores still remain subject to consultation, and no final decisions have been made until everybody's had the opportunity to test the rationale for the scores that have been provided. Next part of the consultation process is looking at ways in which a redundancy situation can be avoided. So this really means inviting proposals from the individual in order to help them to avoid or mitigate the effects of the potential redundancy scenario. So ensure you do this in meetings, in follow-up correspondence. Make sure you're inviting representatives from employees and exploring them. Is what they have said a possibility? Could, for example, some businesses have certainly in the economic downturn a few years ago initially looked at making redundancies and then received a proposal from a group of employees to take a pay cut and move to a temporary 3 or 4 day working week. And employers can sometimes accept that and think, actually, no, it's better to do that and hold on to staff that have been trained and make sure that we're in a situation where we're ready to scale up again if the economy takes a turn for the better. The next part of achieving a fair redundancy consultation process is looking for alternative roles. So the obligation on the employer is to look across the whole of the group. So not necessarily just the business in which the individual is operating, but if you're group companies, the obligation spans across the group as well. And this is a proactive obligation. It's not really good enough to send over a list of vacancies to everybody and think that that discharges your responsibilities here. Businesses themselves need to be looking at the vacancy list, proactively identifying anything which on the face of it might be suitable or could be suitable with a bit of training, and then offer it. So unless there's other suitable employees or other employees also at risk of redundancy who might then need to be placed into a competitive process, the employee should be handed a role that they are suitable and able to do. So not made to apply for it. They might not be the best candidate, but if they are at risk of redundancy, their situation trumps somebody who is not at risk of redundancy or an external candidate, even if they are not the best person for the job. You should review your vacancy list with the employee and make sure that you explore any potentially suitable vacancies with the employee, highlight anything, ask them if they want to consider them, and then put forward any notes of interest so that that individual can be offered the role. Also use this consultation process as an opportunity to address any other matters of concern that have arisen during the process, making sure that we're taking notes, following up on any concerns that have been raised, making sure that you're responding to those concerns, ideally in writing with follow-up correspondence. The more you document in these situations, the better. The more you have as evidence, either in meeting notes or in follow-up conversations, to show that you have taken on board what they have proposed, explored it, and then have a reasonable response for them. So when should consultation start, and how long should it last? This is a question that we get asked quite a lot, because often, especially if the business is in difficulties, there's very much a desire to try and achieve these cost savings as quickly as possible. There's no actual prescribed timescales in which consultation should take place, but the shorter the consultation, the more likely it is that the quality of it is going to be called into question. So in a EAT case back in 2007, Rogers and Slimmer PLC, the EAT held that the tribunal had been entitled to find on the facts that 7 days of consultation with individuals was the bare minimum, but in that particular set of circumstances was considered to be an adequate period. We'd suggest probably more like 2 weeks, but it is going to be dependent on the rationale, the size of the pool, the method of selection, that kind of thing. All of those factors will feed into the extent and length of any consultation period that you need to be following. If an employee isn't consulted until late in the process, it's likely that a tribunal is going to be particularly concerned about the quality and adequacy of the consultation process that's been followed. So we're now going to have a look a little bit more detail at some recent case law around consultation and what the tribunals have been saying. So the first case we're going to look at is DeBank Haycox and ADP RPO UK Limited, and it's a 2023 EAT case. So Mr. DeBank Haycock was employed by ADP to recruit new employees for their client company. So the client company was Goldman Sachs. In March 2020, due to the COVID-19 pandemic, the demand for new employees, so new recruits at the client, diminished by about 50%. So in May 2020, the decision was made by ADP to reduce the number of recruitment staff. At the beginning of June 2020, Mr. DBH's manager assessed and scored her team members with reference to a set of subjective criteria. Mr. DBH scored last in the rankings, and on the 18th of June 2020, the decision was made to reduce the team by 2, and a timetable was set for the redundancy process. So the important thing to notice here is that scoring had happened before the redundancy situation had even been announced. So consultations began on the 30th of June with an initial consultation meeting, followed by a consultation period of 14 days, ending with those leaving being informed on the 14th of July 2020. Throughout the process, Mr. DeBank Haycox was unaware of how he or his colleagues had scored against the selection criteria. His own scores were not revealed to him until he unsuccessfully appealed against the decision to terminate his employment. So the EAT took this as an opportunity to undertake a thorough review of the key case law and held that authorities establish the following guiding principles. So an employer will normally need to warn and consult either the employees affected or their representatives. A fair consultation needs to occur when the proposals are at a formative stage, so still at a stage where an individual has the ability to input into them and make representations. And the individuals need to be given adequate information and adequate time in which to respond, along with conscientious consideration of the response. So whether consultation is collective or individual, its purpose is to avoid dismissal and minimise impact. The redundancy process must be viewed as a whole, and appeal may correct an earlier failing. A tribunal should then consider the whole process, including the reason for dismissal, when deciding whether it's reasonable to dismiss. So whether consultation is adequate is a question of fact and degree, and it's not automatically unfair that there is a lack of consultation in particular respect. Any particular aspects of consultation, such as the provision of scoring, there isn't one key factor that has to be complied with in order for a fair process to have occurred. So it is the tribunal will look at the entire process before making a decision as to whether the consultation is fair or unfair. Using a scoring system doesn't automatically make a process fair, and whether it's reasonable to share the scores with other people in the pool will relate to the specific complaints that are being raised in the individual cases. So that was a really helpful consideration of what the key principles of a consultation need to be followed in order to establish a fair redundancy dismissal. In the EAT's view on this particular case, there was no good reason for the employer not to have undertaken what the EAT described as general workforce consultation. The EAT reflected that for large-scale redundancies, so for redundancies that are affecting more than 20 people, obviously statutory collective consultation requires that employees and trade union representatives are consulted at the formative stage of a potential redundancy situation. The requirements are obviously not quite as prescribed for small-scale redundancy processes. However, the EAT said that when conducting redundancies, reasonableness reflects what is considered to be good industrial relations practice, and that employees should engage in consultation at an early stage of the redundancy process. Individuals should be provided with sufficient information, the opportunity to propose alternatives to redundancy, and adequate time to respond in line with fair dismissal procedure. So one of the questions that we often get is that employers want to avoid causing unnecessary stress to individuals who they consider are going to be safe in a redundancy process. So I often used to get asked the question, not so much recently, but several years ago, can I just, before I announce a redundancy situation, can I score everybody first and then only go into consultation with the people that I've identified as the lowest scoring and therefore potentially at risk of redundancy? And what the case law says is that no, this is highly unlikely to be an unfair consultation process because there hasn't been enough adequate consultation around the scores, why perhaps somebody hasn't had the chance to say that perhaps their score in a particular area is lower because of a particular reason. So the safest way now is to do your announcement, explain your rationale, provide your selection criteria for comment, and then move into applying that selection criteria once people have had the opportunity to feed into it. So moving on to my final slide is considering again sticking with consultation, but looking at the key components for achieving a fair consultation. We have there's a case that was looked at back in 1994 in which the judge in that particular court said that the process of consultation isn't one where you have to adopt the views of the people that you're consulting with. So consulting doesn't mean that you have to accept everything that the employee or the representatives are saying. So it involves allowing somebody to have fair opportunity to fully understand the matters about which they're consulted over and to express views on those subjects, with the consultant taking on board those views genuinely and properly. It doesn't mean that you have to accept the views. You have to just show that you have taken them on board, considered them, and decided that it's not possible to put them into practice for various reasons. So the key elements of a consultation process were identified as being: ensure that you're consulting at a formative stage, so before plans are fixed, and whilst people still have the opportunity to put representations forward, make sure you provide enough information to allow individuals to respond, and make sure you provide enough time to allow individuals to make those representations, and then consciously consider the responses that you receive from individuals. You have to have an open mind, be capable of influence around the matters that have been forming the subject of the consultation. So I'm now going to pass over to my colleague Lucy, who's going to talk a little bit more about selection pools and selection processes.
Oh, thank you, Olivia. Good morning, everyone. I'm conscious that we've probably hit that magic hour now where hopefully I'm going to hold your attention for the next 20 minutes or so as I take you through or navigate you through the final 2 redundancy trip hazards and take a look at, finally, quickly, the new enhanced redundancy protection that's due to come in or may happen in April for pregnant employees and those on family leave. So moving the slides on, I'm going to start by addressing the thorny issue of selection pools. Sometimes processes, because of the nature of the proposals or the roles involved, the pools just can kind of cry out to you. It's very straightforward, but if only it was always that easy. So most importantly, while you might be very excited and want to get carried away with applying your carefully crafted objective selection criteria, the first step is to identify the appropriate pool. Now, some of you might be relieved or actually concerned that there are really no fixed rules as to how a pool should be defined. An employer has a relatively broad discretion or wide measure of flexibility, unless as a business you have collectively agreed or customary selection pools that you need to use. So as ever with discretion in the employment sphere, I'm sure many of you will be familiar with this if you're in HR, that discretion should be exercised reasonably, and what reasonable is often depends on the facts of a particular exercise. So the question of how the pool should be defined is primarily a matter for the employer, and provided an employer has given some genuine thought and applied some logic to how they're composing their pools, it is going to be difficult for an employee to challenge the decision that they've made. It is not impossible, but it is difficult. And often in redundancy exercises, and because of the nature of a business and how employees work and maybe the roles that they do or the multi-skills that they have, a particular set of circumstances could open up a variety of potentially appropriate pools. So there's not necessarily one right way, and it will be for you as a business or for an employer to decide on the appropriate course of action for a particular redundancy exercise. Now, as I think Olivia's touched on, often employees can be keen to narrow those pools to minimise the disruption, employee relations, but there can be occasions where a narrow pool may not be considered reasonable by a tribunal. And as like most things in these kind of processes, be ready to explain to those affected employees your justification for the approach you take. It is likely to come up during the consultation process, so you want to be on the front foot. And the final slide here is I'm going to come into a bit more detail in a moment. We're going to look at a case that sort of illustrates the point. It's where a decision to apply a particular selection criterion inevitably leads to a selection pool of one employee, with the result that the selection for redundancy is made by that decision itself, that application of the criterion. And consultation is only going to be fair if it takes place before the decision to utilise that criterion itself. And as I said, there's a case of McGann and Bradford Teaching Hospitals and NHS Foundation Trust, an EAT, so an Employment Appeal Tribunal decision from 2022, which sort of highlights that final bullet point. This case involved 2 nurses who were engaged on successive fixed term contracts, and an employer, the NHS, needed to make financial savings, and they decided that the person that was going to be made redundant, the claimant, should be selected for redundancy because her contract just happened to be the first of the 2 nurses to expire by the time they identified the need to make cost savings. So the redundancy consultation process following this decision, they delighted on this criterion of whoever's contract expires, next is to go, focused solely on finding the claimant alternative employment. So there wasn't really any meaningful discussion about this sort of selection criteria. And the EAT noted that, and I think what's obviously been borne out by what Olivia said this morning, is that consultation is a fundamental aspect of a redundancy process. It's got to be genuine and meaningful, and it's got to take place at an early stage, so the employee can potentially, and not always, but have an influence over the process and the potential outcome. And that just had not happened here. In this case, the decision to dismiss the claimant on grounds that her contract was the first up for renewal meant the selection pool had essentially been reduced to 1, but there'd been no effective consultation over the use of that criterion. Essentially, the EAT was quite critical of the employer's approach, but I suppose more for you, what does this case mean when you're looking at a redundancy situation where maybe some similar circumstances can arise? The decision does not mean that a pool of 1 for redundancy is necessarily unfair in appropriate circumstances. Always turns on the particular facts of every exercise. But where there is more than 1 employee doing the same job, and the choice of selection criteria means the pool is effectively reduced to 1 by the application of that criteria, it should not be adopted without prior consultation. In this case, the EAT found that essentially the process or the use of the selection criteria meant that the process or the outcome was futile, and the outcome had been predetermined at an early stage. Then we've got another interesting case, again, another case, a decision from the EAT by a case brought by Mr. Teixeira against Seeker Restaurant. Now, the facts briefly of this case, the claimant was one of 10 chefs in a London restaurant. He was the most inexperienced and apparently didn't have a specialisation. I'm not sure what their chef specialisations were, but he was, I suppose, in the employer's view, at the bottom of the food chain. And then during the pandemic, the business was hit hard, as I'm sure many restaurants you can recall were, and there was a reduction in work. So without any warning and without any consultation, Mr. Teixeira was made redundant, and he was the only chef that was selected for redundancy. So it's going to be ringing bells following on from Olivia this morning. So the Employment Tribunal, the first instance decision, surprisingly found that the claimant's dismissal was procedurally unfair. So they went on to consider the purpose of a bulky reduction in compensation. And it went on to consider if and when the claimant would have been dismissed if fair procedure had been followed. And the tribunal found that it hadn't been unreasonable for the claimant to have been placed in a pool of 1, and they really thought that actually consultation wouldn't have made any difference, and he would have been made redundant at the same time, and they reduced his compensation by 100%. And as you can imagine, the claimant wasn't happy about that and appealed to the EAT, and the EAT sided with Mr. Teixeira. They said the possibility of a pool of 1 being fairly chosen did not mean that the dismissal was bound to have taken place when it did. They said that the tribunal's reasoning failed to consider the requirement for some warning and consultation. And if there had been some consultation, it was likely that that would have taken some time. And even if the dismissal was inevitable, it might have been delayed by a week or so. So that would mean that some compensation should be due. The EAT went on and found that it was erroneous for the tribunal to have decided that dismissal was inevitable and that there wouldn't have been any delay, and the case is being remitted back to the Employment Tribunal to consider this a point. It's essentially been sent back by the EAT for the tribunal to mark its own homework, if you like. So those are sort of 2 interesting cases sort of relevant to pooling, but what do you need to be aware of when you're trying to identify an appropriate selection pool? And this slide helpfully sets out the relevant factors that a tribunal is going to consider in relation to the pool. So what type of work is ceasing or diminishing? To what extent are employees doing similar work? Is there interchangeability between roles? Are they multi-skilled? And that's where actually the pooling can become quite challenging. And have you actually genuinely considered and applied your mind to the composition of those pools? Is it logical, or is there some form of logic behind it? So a sensible starting point for drawing up the pool is what the employee actually does. Their day-to-day activities. You can look at the contract, but like most in other areas, when we look at employment status, the contract can say one thing, but what is actually the reality, and what is this person actually doing? Contracts can become, out of step with developments in a person's role, and it will involve probably speaking to managers. Maybe you realise even sometimes managers don't necessarily have a full grip on what people are doing, because you want to be on the front foot, because it could come up as a challenge during the consultation process. So doing good DD to start with, otherwise you could undermine the credibility of your selection pool. And as I've said, it can be more complicated in terms of identifying the appropriate pools when employees are multi-skilled or do different types of work, or could, under the terms of their contract, be asked to do other types of work. So in such cases where there is that interchangeability, you're more likely to get challenge, especially if you've drawn the pool quite narrowly, and you're going to get employees saying, well, why aren't they over there? They do 75% of the role. Why aren't they in the pool with us? Because they want to increase their chances of staying, unless you are in one of those businesses where you have lovely enhanced redundancy, where people might be clambering to go rather than to stay. And I think it's already been touched on. Typically, employers are reluctant to draw the pools too widely, and for good reasons, because it's going to make the consultation process more onerous, because there's more employees to consult with, and consequently there can be a greater impact on morale. And as a fabulous former colleague of mine used to say often in these kind of situations, Lucy, if we put the law to one side and apply some common sense or some commerciality, and often we find that employers sometimes prefer to draw a narrow pool, or, as Liv's touched on, consult those who've been provisionally selected, effectively bypassing the pooling stage. Now, that's fine if you know the risks that you're getting yourself into. And of course, if you take those routes, you are vulnerable to claims of unfair dismissal. But it's a matter of commercial judgment, balancing morale and the administrative burden of a larger consultation exercise versus the risk and costs of claims that you may face from of unfair dismissal from redundant employees. Now, before we leave or exit the pool, if you like, a quick slide on bumping and a sort of quick reminder on that. I have to say, in my experience, bumping doesn't come up very often. Sometimes an employee will raise it as sort of a Hail Mary, so to try and avoid being made redundant. But if I start by explaining it, if it's a concept that not everyone has come across. So bumping is the process of moving a potentially redundant employee, call them A, into another role and dismissing the employee currently performing that role B. So there's still a redundancy dismissal, even if there's no actual or anticipated diminution in the requirements for employees to do B's work. Bumping has been approved back in a House of Lords case back in 1999, case of Murray and Foyle meets. But whether the circumstances of a particular case mean that employers should consider bumping is not contingent on the employee raising it themselves. It's something that you can think about. I think it just can cause issues, it can complexities to a process, and sometimes where you see cases where the suggestion has been bumping down a senior employee into a junior role. Sometimes those employees are not interested in taking a role which may have a reduction in status, money, compensation, etc. But it's just something to bear in mind. Now, moving on to the final redundancy trip hazard for today, we're looking at suitable alternative employment. Now, this is one of the trickier areas. It can become quite technical, especially around statutory trial periods. Every time anyone asks me a question about this, I always have to sort of go back to the basics and the fundamentals. It can be quite tricky. Also, it can lead to disputes because you have employers that perhaps want to save on, making redundancy payments that can be expensive, versus an employee who obviously wants to get the money, and you can have disputes over whether a role is suitable or whether it's an employee has unreasonably refused an offer of suitable alternative employment. So, starting off. So an employer must consider whether alternative employment is available. And I know that we've been sort of touched on this earlier on in the session. And it implies not only to looking for roles within the employing entity. If you're part of a bigger group, you're going to need to get in contact perhaps with other HR or talent acquisition teams in other group companies. So an associated employer is where one company has control, directly or indirectly, over the other parent or subsidiary, or both are companies under the control of a third group company. So it could mean that you're going to have to get in contact with your broader group HR teams, as I've said, to get a comprehensive list of available or potentially available suitable roles. You've got to make reasonable efforts to look. As Liv has said earlier, it's not enough to just go, here's the link and have a look on our TA screen. You need to actively look for potentially suitable roles for employees and bring them to their attention. And it is a fundamental part of a redundancy dismissal process. You cannot move this out. It might be that you look and there is nothing. It gets more complicated when there are a variety of roles and a number of at-risk employees competing for them. You are not required to create alternative employment for redundant employees where none already exists. However, you should make sure that you undertake a sufficiently thorough search. And as ever in employment, document that search. If it becomes contested later on in an unfair dismissal, you want to know and be able to clearly demonstrate the extent of the search that you undertook and what roles were available at the relevant time. And as the slide says, it's an ongoing duty. So many of you may well have redundancy exercises where you're looking for alternative employment during the consultation process. And once the decision's paid, people might be paid in lieu and off they go. But where you've got a situation, you mustn't forget if people are working their notice, and it could be up to say 3 months or longer, you have an ongoing duty to look for alternative employment that may arise suitable during a notice period. So it's very much that sort of continuous up until their last date of employment. And also, it's not just sort of here's a job title. Employers have got to provide meaningful and sufficient information about vacancies so that the employee who's at risk can take an informed view about whether they think it's suitable or not and whether they're interested in taking up the role. So, what is the effect on an employee's entitlement to statutory redundancy pay where an employer offers suitable alternative employment and the employee unreasonably refuses? Well, it means they lose their entitlement to statutory redundancy pay. So that's why it can become quite contentious. So an employee's contract of employment will not come to an end if the employer offers either to renew their contract or to re-engage them under a new contract, whether with the same employing entity or an associated employer, which I referred to earlier. So where an employer makes an offer of suitable alternative employment and the employee accepts or rejects the offer, under the Employment Rights Act, it sets out the effect on an employee's contract of employment and their entitlement to a statutory redundancy pay. So where the employee unreasonably rejects an offer of suitable alternative employment, they're going to forfeit their redundancy payment. And in some cases, that could even result in forfeiting a very nice enhanced redundancy payment. So where suitable alternative employment is offered, it is subject to a statutory 4-week trial period if the terms of the new employment differ in any respect from the employee's existing terms. And what does that look like? Well, what you've got to be looking at is all differences count unless they are trivial or insignificant. So from the current role to the role that you're offering as an alternative. Each employment term is considered individually, so sort of benchmarking each term, and a contract is not considered on the basis of the overall effect. So the fact that the new terms may be more favourable than the old terms also isn't relevant. It's still seen as a difference. It's a bit more on statutory trial periods. So the purpose of the trial period is for both parties, the employer and the employee, to assess suitability of the alternative employment for the employee. So a statutory trial period may be extended to last longer than 4 weeks, only where essentially the employee needs to be retrained in the alternative role. I often get clients that think quite rightly that 4 weeks isn't really enough and sometimes want to try and seek and push those boundaries, and it's really whether training is really a requirement. The slide helpfully sets out there in those arrows the potential outcomes and consequences flowing from that trial period. So if it's successful, there'll be no dismissal for statutory redundancy purposes, they continue to be employed, no redundancy payment, and hopefully everyone's happy. If the trial period is unsuccessful, the employee is dismissed from the date of the original contract terminated, so when they would have been made redundant. They get the statutory redundancy pay unless they've unreasonably refused an offer of suitable alternative employment. Just to kind of touch on the administrative elements, if you like, of a statutory trial period. So the scheme requires that an employer and employee can agree to extend where there's that training requirement, but you must have in written agreement, be in writing and finalised before the employee begins work under the new contract. State the date on which the employee's retraining will finish, and identify the terms of employment that will apply after the employee's retraining has finished. I think if you're ever getting into a situation where you haven't dealt with statutory trial periods before with the extension for retraining, it's worth getting advice on, because as I've said, it can be quite technical and you want to get into sort of the granular detail to make sure everything works out. So moving on to how do you assess whether a role is suitable in the first place, and how do you know if a refusal has been reasonable by an employee? And this slide sets out the relevant considerations and the matters that a tribunal would have regard to if it became contentious. So, in making an objective assessment of suitability of alternative employment, a tribunal is going to have regard to the employee's skills, aptitudes and experience, and essentially whether they meet the requirements for the job on offer. And then they're going to look at the terms of the alternative role. So status, place of work, the tasks they've got to do, the hours they've got to work, and their responsibility. But note that whilst an employee might be willing to dip their toe, if you like, and accept a trial period, that does not mean, or is not evidence that they consider it's necessarily suitable. Because remember, the purpose of the statutory trial period is for both parties to sort of road test the suitable alternative employment to see if it is suitable in the first place. Then turning to the reasonable refusal. So whether an employee's refusal of suitable alternative employment is reasonable does not depend on what a reasonable, like an objective test, a reasonable employee would have done in the same circumstances, nor should the tribunal apply a band of reasonable responses test. What's got to be looked at and assessed is whether the particular employee, taking into account their own sort of personal circumstances, were they being reasonable in refusing the offer. And they can take into account factors, their life outside of work and how the change in role could actually impact on that. So it's things like status, are they going to be required to relocate, even in reported cases where there's been a slight increase in commute, you wouldn't think it was necessarily substantial at first look, have found to be a basis for a reasonable refusal. Also, the new role could result in a change of career, which quite frankly wasn't the career path that the employee wants to go on. And again, that could be potentially a reasonable reason for refusing suitable alternative employment. Just quickly, I'm conscious of time. On suitable alternative employment, my final slide is about a case which considered whether 3 employees had acted reasonably in refusing suitable alternative employment when their roles were made redundant. All 3 were heads of HR, and during the restructuring process, they were all offered suitable alternative employment, or that's what the employer thought, as senior HR leads. Every single claimant, all 3 of them rejected the alternative roles because of a perceived loss of status and autonomy. And the trust decided to refuse to pay their redundancy on the basis that they'd unreasonably refused the HR leads roles. I won't go over again the test given the time, but I think the ET held that the alternative positions were suitable, but the claimant's refusal to accept the post were not unreasonable as their perception they would lack autonomy in the new roles was not groundless. There was a change in reporting structure, but no loss of status. And that decision was upheld by the EAT, meaning that claimants retain their right to receive redundancy pay. I think a practical note from that then is perhaps some of the perceptions weren't quite correct of the claimants. It's quite important, I think, as an employer, when you're identifying alternative roles, to sort of explain the full remit of the role and address any concerns an employee may have if they've got, an incorrect perception of the role, if you're going to try and encourage them to stay and avoid, paying out a statutory redundancy payment if they refuse the role. Now, finally, the topic today, increased redundancy protection. So the existing position is that redundancy protection applies during maternity, adoption and shared parental leaves, the protected period. Employees are entitled to be offered alternative employment if there is any, in preference to other redundant employees. So effectively, this means that employees move to the front of the queue ahead of any other colleagues who are at risk and are given first refusal for roles. Otherwise, if you fail to do that, the employer risks an automatic unfair dismissal claim. Now, the protection, potential future, the Protection from Redundancy, Pregnancy and Family Leave Act came into force in July of last year, allowing for secondary legislation to be made, which should set out the detail of the new rights and how they would work. And the draft maternity leave, adoption, leave and shared parental leave amendment regs were laid before Parliament in mid-December of last year. If passed, these additional redundancy protections will apply during pregnancy and after a period of relevant leave. So the period of protection after returning to work from relevant leave will be known as additional protected leave. So where the protected period covers pregnancy, the new rules would apply where the employee notifies their employer of their pregnancy on or after the 6th of April this year. Where it relates to a period of relevant leave, the new rules would apply to maternity and adoption leave ending on or after the 6th of April this year, and to a period of at least 6 consecutive weeks of shared parental leave starting on or after the 6th of April this year. Now, the next slide just sort of sets out quite helpfully what this looks like. So the duration of additional protective leave that applies after return to work is going to vary depending on when the leave commences in relation to the birth or adoption and the duration of the leave taken. But the overall protection post-birth or adoption is going to remain the same, 18 months in total. So you're going to have to get used to doing some calculations behind the scenes, but the overlying principle is an 18-month period of protection. Just to flag, the protection offered under the old Regulation 10 of the maternity and parental leave regs is only triggered once an employee has been selected for redundancy. It should not be factored into the selection process itself. And if an employer automatically selects a woman on maternity leave as one of the employees to be retained, effectively taking them out of that selection pool, it would run the risk of committing sex discrimination against any male employees in the pool. It would essentially be going a step too far and a layer of additional protection that wasn't permitted. And this is because an employer would arguably have gone further than was reasonably necessary to avoid any disadvantage to women arising because she was on maternity leave, and that's even one of an issue that Foxed a large law firm Eversheds a number of years ago in the case of DeBellin. So you can go only so far as permitted under the regs, don't go too far. That's all I have, so I'm going to hand back now to Sam, Master of Ceremonies, who hopefully will take over the screen.
Thank you very much, Lucy, and to Olivia and Sonia before. So we've now entered into the Q&A session, and I can see that there's been lots and lots of questions that have been raised. This is clearly a hot topic for organisations on the agenda for 2024. So I'm going to go straight into questions. Olivia, I'm going to start with you. Please, can you clarify how redundancy pay is calculated?
So redundancy pay is calculated based on a formula that looks at your age, your length of service, and a week's pay, which, as Sonia described, is going up as of the start of April this year. You're not entitled to any redundancy pay if you have less than 2 years service, and after that it is, as I say, it's based on age, length of service, and capped pay. We do have a Birketts employment app which has a redundancy calculator on it, so we've done all of the hard work for you. If you want to download the app from the App Store, or you can access it through one of the QR codes that we've got, then it will do all the maths for you.
Thank you, Olivia. And to Lucy, do you have to go through a redundancy process if an employee has less than 2 years service? So we know they're not going to be entitled to pay, but do we have to go through a redundancy process for that?
I suppose technically no. And I mean, if it's just their role, then you could do a sort of short service dismissal if you like. It depends, I suppose. Yes, I suppose potentially not, whether as a business you want to do that if there's more than one person involved. And I'm talking on like an individual level here. Obviously, collective adds a layer of complexity, which I don't think we're addressing today. If that makes sense.
Yep.
So yeah, they don't have ordinary unfair dismissal rights. So
absolutely.
you could be
And
brutal.
I'd add to that since in some situations there could be a risk of a discrimination claim or an automatic unfair dismissal claim where employers can fall into the trap of not following that rudimentary process and going through that consultation process that we've talked about today, and then find themselves with a claim saying, well, you only selected me because I have a protected characteristic or I blew the whistle, for example. And then in those situations where there is a risk, we would always advise there being some process that you would go through to be able to justify that this is a genuine redundancy situation as opposed to an impermissible reason to dismiss. Olivia, can you comment just briefly, because I'm aware of time, around whether it is appropriate where you've got a situation for making people redundant and also restructuring, whether you would deal with that all in one go or in separate processes?
Sure. So redundancy situations obviously give rise to the classic scenario of reducing headcount, but quite often in those situations we're also looking at cases where individuals' roles might not be redundant, but there might be changes being made to their role, which we have to address by way of doing a change in terms and conditions process. So you end up sort of arguing two types of reason for dismissal. One could be redundancy, one could be some other substantial reason. You do that all together at the same time. So you consult on the overall rationale. Typically, it will be the same. The reason for changing somebody's terms and conditions can obviously be related to the underlying reasons for the restructure. Change in terms and conditions will also, if you're looking at doing that for more than 20 people, will typically still also result potentially in dismissal. So you've got to fill out your HR1, and you might have to do a collective consultation as well. So wrap that all up together and make sure you are following those additional steps as you need to.
Thank you, Olivia. I mean, I'm afraid that is all the time we have for questions today. We have slightly overrun, so apologies for that. Lots of the questions were covered in the material that we have presented on today anyway. But if you do have any questions that you would like one of us to answer, then please reach out to one of us or one of the Birketts employment team, or you can email events@birketts.co.uk. We will be sending out a copy of this recording to you all as promised, and there will be a short feedback survey which we would really be grateful if you could complete, which informs what we do for future events. And we hope to see you all at one of our in-person early bird seminars in June, July time. So until then, thank you ever so much for joining us and have a great day.
Goodbye.